Very good evening to all of you, and welcome to uh, the weekly online lecture series, Know Your IP, organized by DPIIT IPR-Chair, Osmania University. And before I formally introduce and invite the resource person of the day, Dr. Gargi Chakrabarti, I would like to say a few words on the topic chosen by the resource person. Among all the forms of intellectual property rights, probably the plant varieties protection is one area where not much focus has been, uh, in fact, concentrated upon by the legal academicians. In fact, I come across many agricultural scientists or biotechnologists and others, or even some farmers organizations speaking more about the plant varieties protection than the legal academics. Reasons could be many. I'm not here to, in fact, find out the reasons, but nonetheless, we need to understand the importance of intellectual property rights in the plant varieties and also farmers' rights. And that is a precise reason why, when we requested Dr. Gargi to speak on a topic of her choice, we were delighted to, in fact, find that she is going to address that very same area which has been reportedly, under concentrated. Therefore, I take this opportunity to thank Dr. Gargi Chakrabarti, and you know that whether it is the Monsanto or the BT cotton and many other areas where, in fact, there are a lot of stakeholders. It's not only the farmers, but also the seed companies, then the biotechnology related, industry, even agricultural universities, agricultural research. This is one area which needs a lot of focus. And even the enactment of the Act of these plant varieties and farmers' rights protection probably has not really resulted in effective protection of many of the farmers' varieties, at least. That is one feeling. Therefore, I, in fact, feel that Dr. Gargi will be highlighting all these important areas. Before I formally invite Dr. Gargi Chakrabarti, I have great pleasure in introducing her to all of you. Dr. Gargi Chakrabarti is currently the Associate Professor of Law at NLU, that is National Law University, Jodhpur. And she was a post-doctoral research fellow at Max Planck Institute of Innovation and Competition, Munich, Germany in 2020. You know that Max Planck Institute is very well known for intellectual property. She has been awarded a Ph.D. from NALSAR University of Law, Hyderabad, and probably where I must have met her offline or online in one of those meetings. And M.Phil from National Law School of India, University, Bangalore. So two important degrees from two very famous national law universities in India. She has done LLM in international law and comparative IP law from London Metropolitan University, London, UK, which is another feather in her cap, with more than 14 years of teaching and research experience. Dr. Gargi is focusing on areas like the intellectual property law, cyber laws, competition law, and environmental law. And she is a tutor for WIPO Academy and completed 4 distance learning courses successfully. So right from DL 101 to many others. And with more than 40 international and national publications in her credit, her achievements include being an IP expert for PIC and a member of Rajasthan State IP Council, Department of Science and Technology, Government of Rajasthan, technical expert for QCI, NBA, UNDP Access and Benefit Sharing Scheme, that is ABS project, for developing certification criteria for the ABS scheme in 2021. Then she has completed a project on ABS mechanism in Rajasthan with UNDP, Government of India, and National Law School of India, University, Bangalore in 2018. Then she has been associated with the 13th Colloquium for Teachers of IP organized by WIPO and WTO in Geneva in 2016. In fact, this is a prestigious, assignment and a wonderful experience for all the IP professionals. And she has been a visiting scholar to School of Law, University of Washington in 2015, and University of Washington Google project on intermediary liabilities on hate speech and online child safety. These are only the snippets of the young and dynamic resource person today. I, on behalf of the DPIIT IPR-Chair, Osmania University, Hyderabad, and my team consisting of Dr. Irfan Abbas, Mr. Srinivas Rao, Mr. Nagaraj, and Ms. Vaishnavi, invite the resource person particularly and all the participants to this series, which is a lecture series and the 7th lecture by Dr. Gargi Chakrabarti. And it's over to you, ma'am. Welcome.
Thank you so much, sir, for your kind words and kind introduction. Yes, my topic is today effectiveness of plant variety protection. Now, I'm not exactly, you can see from my introduction part or just to tell about how it is started. So, before TRIPS, we have UPOV. So US, all the European countries and good lot of other countries, now African and Latin American countries, also part of this particular um, plant variety protection regime. So now the thing is like that India is not the signatory country of UPOV. Now when TRIPS came 1st January 1995, initially we thought TRIPS is going to address counterfeit and piracy, but it was not the thing. We know that all segment of IP subject matter addressed and very elaborately what or not, anti-competition, enforcement, every possible thing TRIPS discussed. But during the TRIPS, we know that previously Paris Convention was there, Berne Convention for the copyright, Paris Convention for the industrial property, for trademark, patent, industrial design. Not was, is there till now, because till we have convention application under the Paris Convention. So we have taken a good lot of provision from the Paris for trademark, for patent, for industrial design, from Berne Convention, for broadcasting and performance rights from Rome Convention, from Washington Treaty or IPIC, we have taken the semiconductor chip provisions. But interestingly, TRIPS quite silent of considering the UPOV. Now, the history or during the negotiation or discussion, so they have sent for the commentaries. So countries are silent about that. Now, it's not clear at that time. They don't want, and there were certain apprehension to go for the plant variety protection under intellectual property rights, though the UPO was there and they're part of it. So what happened? We know why I'm giving the reference of TRIPS, because today we have 2001 Plant Variety Protection and Farmers' Rights Act after TRIPS. So TRIPS is not optional. It's a mandatory nature, correct? So every possible WTO member country must have that. So it's a laying down the minimum standard for the IP. Now, Article 27(3)(b) where the non-patentable subject matter mentioned, only one sentence written for the plant. That is, plant can be protected either by patent or sui generis or combination thereof. So now it's up to the member country. They are part of the UPOF, fine. They are not part of the UPOF, now need to take the call, legal call, how they're going to protect the plant variety protection. So options are three: patent, sui generis, or combination, patent plus sui generis. So India opted for the sui generis option, that is Plant Variety Protection and Farmers' Rights Act. As such, we know that Section 3J of our Indian Patent Act in 1970, we have mentioned part, whole or part of plant is somehow not protected under the patent. So that's there. So this is the situation. Now, why the UPOV was not under consideration, and till now we are not the signatory countries, and we have now our sui generis mechanism for the plant variety protection and farmers rights act. Now we need to understand the socio-economy and socio-cultural situation of India little bit. India is agricultural based country, and the agriculture is farmer based. So rarely, specifically the state I'm coming from, it's a very fertile land, West Bengal, but we have very small lands. I mean, most of the eastern part is having not like Punjab, Haryana, hectares of lands. So it is rare in our cases. So small lands and farmers, and sometimes they don't own even their own land. Someone else's land they're just cultivating, and either they're getting certain portion of the cultivation or some money arrangement somehow. This is the survival for them, a livelihood for them, you can say. So basically the agricultural practice is very different from the European Union, from the US, Canada, Australia. So we are a farmer based country, not the corporation based agriculture. So the approach is totally different. So we need to go by that particular understanding. We can't seriously cannot replicate or cannot copy others just seeing their success. So we need to understand from our where we are standing, what is our socio-economic condition, what is our agricultural situation. So the thing is like that, our good lot of festival, just now we have done with those festival: Makar Sankranti, Sankranti, Bihu, Pongal, Lori, all these harvesting festival. So this is the festival where farmers share the seeds. They celebrate that particular, having the cultivation and planning for the new cultivation. So this is the thing. So here we are not thinking primarily the monopolizing the thing. We are thinking primarily the sharing the seeds, helping each other. So philosophically, we are standing in a separate way. So these are before thinking about the protection and today's globalization, where we are standing. So root, we can't deny our root. So this is our country. Now I'm coming to the Plant Variety Protection and Farmers Rights Act. So starting with, what is the objective of this particular act? Okay. So first and foremost, to establish an effective system for the protection of plant varieties. Now, what is know the background of all the participant, but considering there are so many legal participants, so I'm just in a very simplistic manner try to make give you the understanding of plant variety. So a number of time I'm going to tell about the plant variety. What is the plant variety? Okay. Now the thing is like that. Uh, think in this manner. Flood came and washed the land. So it just washed the crops. Then the farmer notice, observe very keenly, 4 5 seedlings of plants still survive. Though the whole, I mean, land washed out with the flood water. The farmers picked those seedlings, start cultivating those. So recognize that it is having certain flood resistance quality or characters. So next generation, more number increase, next generation. So normally in this manner, natural selection usually takes 7 generation. It's a long-term process. Then in the 7th generation, after 7 generation, the farmer is getting that flood resistance variety. Okay, now I'm coming to another simplistic way. Now I don't have red capsicum. Now when I'm cultivating, I find it out some green capsicum is having the red tinge for whatever maybe the reason. So I just collected those seeds, start planting those. Then more red, then more red, then more red. Then I'm getting the red capsicum. So now it is different. Green capsicum, then I got the red capsicum. After 7 generation, I got the red capsicum. So it's a new variety I developed through the natural selection. Okay, so you will get that when I will explain the criteria even. So in this manner, whenever anyone is developing the new variety, till now I am talking about the natural selection. I never enter, I mean, till now, I'm not touching the laboratory intervention as such. I will come to that. But this is the thing. Now come to the objective. So establish an effective system for the protection of plant varieties. Now we know whenever anyone is coming with the new varieties, there is a need of protection. The rights of farmers and plant breeders, and to encourage the development of new varieties of plants. So, general understanding of intellectual property rights, we know that whatever may be the subject matter of IP, the basic understanding is what? So, we are investing our intellect, we are investing our money. So, we are looking forward to recover those investment, intellectual investment, monetary investment, skill investment, energy investment, all these things. So whatever we are investing, we are looking for some return out of it. That is the first one. And second one is what? Acknowledgement or recognition. Someone developed that. So who developed that? That recognition is needed. Third point is what? I need to combat with the unfair competition. So someone is a replicate, or someone is doing something, copying or something like that, then without putting the intellect, investment or something like that, but start making money out of it. So it is giving certain unfair competition from the third party to stop that. So these are the very basic understanding for every possible intellectual property rights. So why we are looking for any protection? These are the main reasons. Okay. So the effective protection, we are encouraging this to recognize and protect the rights of the farmers in respect of the made at any time of conserving, improving, and making available plant genetic resources for the development of new plant variety. Now, I know personally someone, again from my state, West Bengal, that he has revived lost 118 varieties, rice varieties, actually lost. So in this manner, the farmers or even the breeders, what is the difference between farmers and breeders? I'm coming. We need to recognize those. There is a need to enhance that, to conserving. So conservation accelerate the agricultural development in the country, protect the plant breeders' rights. So some extent, again, the agricultural university, companies, so this type of organizations also coming into the way, stimulate investment for research and development, both in public and private sector, for the development of the new plant variety. Facilitate the growth of seed industry in the country, which will ensure the availability of high quality seeds and planting material to the farmers. So these are the things we keeping in mind when Plant Variety Protection and Farmers' Rights Act came into the way. Some important definition I have to mention here to distinguish from one to other. That is, who is farmer here? So as per our act, who cultivate crops by cultivating the land himself, or cultivate crops by directly supervising the cultivation of land through any other person, or conserve and preserves severally or jointly with any person any wild species or traditional varieties, traditionally trial and error method. I told about the natural selection, and it's a trial and error method. So they didn't know, maybe, I mean, if I'm going back, thousand and thousand years back, so they need to wait for the seventh generation to develop one particular variety. So gradually came. I used to tell in my class even that we always give a very less importance, or we never think that engineer or biotechnologist or very posh or very lucrative, in a similar manner we can consider our farmers. They're very highly intelligent and high skilled person. We have high contribution, and whenever we are recognizing them through this total process, end of the day, like access to medicine, this is the point of the food security. We can survive without a mobile, without a good lot of electronics gadget, but we can't survive without food. Very basic need. Okay. Now, who is breeder? A person or group of person, a farmer or group of farmers, or any institution which has bred, evolved, or developed and variety. So you just heard about the breeder's definition. Breeder, a person or group of person, or a farmer or a group of farmers, or any institution which has bred, evolved, or developed and variety. Okay. Now, of course, variety, a plant grouping except microorganism. Here we are not at all calculating the microorganism. Now, within a single botanical taxon of the lowest known mark, defined by the expression of the characteristics resulting from a given genotype grouping, distinguished from any other plant grouping by expression of at least one of the said characteristics, considered as an unit with regard to its stability for being propagated and remains unchanged after such propagation, includes propagating material such variety, extant variety, transgenic variety, farmer's variety, essentially derived variety. Now, already variety given the hint, the definition of variety given the hint of the criteria of the plant variety. Now, we actually consider the criteria, DAS criteria, though India follow a DAS criteria, but mostly we are depending the DAS criteria. If you visit the website of the plant variety authority, you can see that every possible crops is having DAS center. Now, DUS, distinctivity, uniformity, stability. This is the, we know that intellectual property is criteria based subject matter. Each and every intellectual property is having certain criteria. They need to fulfill those criteria, then only they can get the registration. So for trademark, they should not come under the absolute ground of the refusal, relative grounds of the refusal. For copyright, it should have originality. For patent, it should not come under the non-patentable subject matter. It should have novelty, inventive step, commercial application, full disclosure of the invention, then only they can get the patent. So in the same manner, plant variety is having the criteria. So these are the very basic of the. So according to that, DAS criteria, distinctivity. Now, again, remember my example, the red capsicum example. It's pretty easy to now understand the DAS criteria. So what is the distinctivity? It is distinguishable from green to red. So one character should be distinguishable from the previous variety. From the parent, what is the next variety we got? So this is the distinctivity. Second, uniformity. So when after 7 generation, I got the red capsicum, uniformly I am going to get the red capsicum only. So 8 generation, I am getting the red capsicum. So at least 99% I am getting the red capsicum. So that is the uniformity. Now stability. Stability means what? I can again cultivate from those seeds. It's not a one-time wonder. Again and again. That is called stability. So DAS criteria, distinctivity, uniformity, and stability. These are the 3 criteria. Now, with that, novelty is also there. But mainly we depending on the DAS criteria. UPOV is also, interestingly, now simultaneously I'm going to tell or compare the thing. Though we are not part of the UPOV as such, maybe we have no plan very recently to join the UPOV, but how much these things are very close to each other, that also I'm going to mention on and off. So UPOV is also having the same. And interestingly, the definition we have just now gone through, breeder, they have only one, breeder. And exactly the same way, under the definition of the breeder, they have included the group of farmers also. But as such, there is no farmers' rights. As such, there is no mention about the farmers. They only mention about the breeders. Now, whenever we listen the word breeder, we always think from a company perspective, from agricultural institute perspective, agricultural university perspective. So we think always from that. Not we are thinking from a very farmer. I mean, what we understand by the farmer, not from that perspective. But our breeder definition and UPOV breeder definition, both are somehow covering the group of farmers. Okay. Now, so now the thing is like that. In India, we have mainly 3 variety: farmers variety, extant variety, and essentially derived variety. Farmers variety, a variety which has been traditionally cultivated and evolved by the farmers in their field, or is a wild relative or land race which farmers possess the common knowledge. So generation after generation, they know that trend, they evolve their own skill and they're doing that particular thing. So that is the farmer's variety, traditional variety or wild variety through the common knowledge, whatever they are developing. Now the next one is the extant variety. Extant variety also include the farmer's variety and the variety about which there is a common knowledge and which is also in the public domain. So this is the extant variety. So from those variety, these are not present in the UPOV. So where the Plant Variety Protection and Farmers' Rights Act is unique, because at the very starting moment I have told, India or India-like countries is having a different footfall. We need to understand from our perspective. So recognizing our perspective or respecting our perspective, these typical definitions are unique, which is not present in EOPO. Now, lastly, essentially derived varieties, yes, everywhere it is present. Essential derived varieties, I just told that sometime farmers or like a farmer who are dedicated to it, they revive the lost varieties. So what happened? Suppose it's need basically their own knowledge, skill, and good lot of R&D also. So now the thing is like that, again, in a very simplistic manner, I'm just trying to give you the example to make you understand. Suppose Shimla mirch or capsicum vanished, hypothetically vanished today. So we are not going to have that, vanished. So how can we revive? Now the family of the capsicum is chili. So someone figure it out that one typical particular chili can again revive the capsicum. So figuring out through the R&D that particular variety of chili and reviving the capsicum once again. So essentially derived variety. So you have derived once again from one typical parent, that particular variety which is lost. Okay. Now I know specifically because as you heard that I was in Max Planck. So they are actually, so there is no as such very elaborate explanation or criteria or something is missing. So Max Planck even is working for elaboration of the essentially derived variety. So in this manner. Okay. Now, after clarifying all those things, who can apply? That is the question. Any person, as per section 14 of our PVPFRA, any person claiming to be a bidder, any successor of the bidder, any person being the assignee of the bidder, any farmer or group of farmers or community of farmers claiming to be a breeder, or any person authorized by a person in a prescribed manner, whatever I have told, the 4 points, any person claiming to be a breeder, successor of the breeder, any person being the assignee of the breeder, any farmer or group of farmers or community of farmers claiming to be a breeder, on their behalf, whoever is applying or they have authorized that person, any university or public funded agricultural institute claiming to be a breeder. Okay, I will come to the uh, analysis later on. Now, what can be registered? Who can apply? Just now we came to know. Now, what can be registered? So we are already know that we have farmers variety, we have extant variety, and we have essentially derived variety. Correct? So such genera and species. So if you can remember school level biology even, then also you can remember that there is a family, then genus, then species, then with the genus and species we used to write a scientific name like rice, Oryza sativa, in this manner. So that's the way. So genera and species as specified under that extant variety, which is coming under the common variety, is included in within the purview of the extant variety. And for the extant variety and essentially derived variety, government actually notify that, gazette, that this could be. So there is a specific thing. So every new variety, criteria of novelty, clarified distinctiveness, uniformity, and stability according to the act it's supposed to be. Now, for the novelty, if the propagating or harvested material of such variety has not been sold or otherwise disposed of by or with the consent of his breeder or his successor for the purpose of exploitation of such variety in India or outside India in case of trees or vines earlier than 6 years. So for crops, what is the thing? So this is not actually disposed of, or they have harvested or they have exploited 1 year before the registration. It has not been in this manner. So if it is not for 1 year before the registration, so you can ask the novelty for that. And of course, one essential characteristics, as I have told, that distinctiveness, that green capsicum to red capsicum, so it's distinctive. Then uniformity, and then the stability. Now, what cannot be registered? Now we came to know what can be registered. Now what cannot be registered is not capable of identifying such variety. So I cannot substantiate why I am asking this is a new variety. It's a flood resistant variety, drought resistant variety, pest resistant variety, insect resistance variety, having vitamin E enriched, having less water content. What? I need to substantiate it, the character. So it is not identifiable. So I cannot get the registration. Consists solely of figure. So the thing is like that. See, I can understand. A basic knowledge I have, even I gathered the practical knowledge. On paper, I have made it. No, on paper, you are not going to get. You have to have the practical thing. You have to be ready with. You can produce the sample, then only. Is liable to mislead or to cause confusion concerning the characteristics. So you're claiming something, but it is not really conveying clearly. It is quite confusingly misleading, whatever you are claiming. No, you are not going to get that. Okay. Now, next one is not different from every denomination which designate a variety of the same species or to closely related species registered under this act. Now, distinctivity feature is so close to the previous variety. I mean, it's very difficult characteristics wise, make it different. Then also you cannot. Okay. Now, is likely to hurt the religious sentiment of any class or section of the citizen of India. I'm sorry, I didn't came across such case, but as a provision we are having in the PVPFRA, so I'm mentioning it. Now, is prohibited for use as a name or emblem of any of purpose mentioned in the section 3 of the Emblems and Names Protection of Improper Use Act. So we know that our Ashok Chakra, national flag, Ashok Stambha, so these are the Emblems and Names Acts is there. So if it is contradicting with that act, you're not going to get it. Is comprised solely or partly of geographical name. Okay, now this is that again time to clarify one thing. Now, recently I used to have a very common question that plant variety, agricultural product, geographical indication, and our plant biological resources. They're different. So just now I have told one thing. Intellectual property law is a criteria based subject. So you have to fulfill the criteria, then you can get that particular protection. Just now I have mentioned even that for trademark we have not come under the absolute ground of the refusal, relative ground. For patent it should not come under the non-patentable subject matter. Then novelty, inventive step, commercial application, and full disclosure through the specification must. Then only you can get the patent. Same manner, plant variety, just now we talked about the endas. So novelty, distinctivity, uniformity, stability. These are the criteria. Geographical indication. What is geographical indication? So geographical indication is those products which is specific for that particular geographical reason. So the weathery condition, maybe specific soil, specific humidity, temperature, all these things is giving, it's a pure sense of gift of nature, gifted by that particular geographical area. Okay, like our Shahi Lychee from Bihar, Kesar mango, Alfonso mango, Himshagur mango, good lot of mangoes, good lot of rice variety, each and every possible place is having their uniqueness. So unique agricultural product coming from a specific geographic location because of the geography. That is the criteria, which is quite different from the plant variety. Now, if I come up with a new variety by a crafted way, it's a plant variety. Go to the plant variety protection. It is not coming under the geographical indication. So we have a very strong geographical indication legal regime. So with the geographical name, if I'm going for the plant variety protection, it is difficult. Now, for the biological resource, plant biological resource, we have Biological Diversity Act. Correct? So plant biological resources, we are utilizing it. And there is another mechanism, access and benefit sharing mechanism. So we need to go by that. So you can see the umbrella term is a plant genetic resource, but under the plant genetic resources, plant biological resources, geographical indication agricultural product, and plant variety protection, they are not synonymous to each other because their criteria are different, their rights are different. Okay, very quickly I need to come to the other thing. So procedure as such, again the same manner, a very basic understanding, every possible intellectual property is same way, application, then whatever may be the correction they usually give that correction, then of course they advertise for the advertisement and opening for the opposition, and if there is any opposition, then opposition, and then issue of the certification, certificate of the registration. Now the point is, all these formalities not for the farmers, all the formalities just for the breeders. Okay, that is the thing. Now duration for the plant variety, it is after certificate of registration shall be valid for 9 years in case of trees and vines. Vines, you know, they're creepers. And 6 years in case of the other crops. Now, in case of, it could be renewed for trees and vines, another 9 years. So total 18 years from the date of registration, not like patent or trademark, from the date of application. Here it is from the date of registration. In case of extant variety, 15 years from the date of notification of the variety in the central government. I told that central government usually for the extant variety or for essentially derived varieties, they put in the official gazette. That's there. For the essential derived varieties, you need to submit the parent from where you have derived that particular variety and the new derived variety. So both you need to submit. Even the plant variety authority, they run the test, if very thorough examination, on field examination, and as after satisfying that, then only you can get that. Now, rights of the breeder. After getting the certificate of the registration for the variety, exclusive right on the breeder or his successor or his agent or licensee to produce, sell, market, distribute, import, or export the variety. In case of extant variety, unless a breeder or his successor establishes right, because extant variety, farmers variety, expected it is coming from the farmers. The central government or state government notify under Section 5 of Seeds Act, this is the variety shall deem to be the owner of the such variety. Now, what is the farmer's variety? Now, farmer's variety, farmer's rights, a farmer shall be deemed to be entitled use, sow, resow, exchange, share, or sell his farm produce seed, subject to the farmers shall not be entitled sell branded seed of a variety protected. So it is not expected from a farmer ki wo, I mean, they are filling up into the sack and they're putting their logo and they're selling. No, of course not. So roughly they're selling. So it's from a farmer, we are not expecting the branded thing. So this is the farmer's right as such. Now, 2-3 things I just want to mention here. One is the, I mean, if any breeder taken the variety or seeds from the farmer and then they develop certain other variety, so after that they got the economic benefit out of it. So again, like our biodiversity act, biological diversity act, here also we have a provision under section 26, benefit sharing. So they need to claim that I mean, we need to read the section 26 and section 41 together. So any person, group of person, or a firm, or a governmental, non-governmental organization can submit a claim of benefit sharing of such variety in prescribed form, such a period of accompanying such fee, then you can get the benefit sharing. That is the one thing. Now, another thing, that benefit sharing because of the contribution by the person or group of person, I mean farmer or the community. So in this way, or in case of essential derived varieties, you have got the parent variety from someone, in that case also you can ask the benefit sharing also. Okay. Now, in case another good another thing is that compensation claiming. Now, some breeder claim that the performance of the seed is so and so, but in reality it didn't happen, then you need to apply to the authority for compensation because of the false claiming. Compulsory licensing, in a same manner like our patent, that after expiry of the 3 years from the date of issue of the certificate of the registration of the variety, reasonable requirement of the public for seeds or other propagating material of the variety have not been satisfied, and that the seed or other propagating material is not available to the public at a reasonable price, and I mean, then anyone can ask for granting the compulsory license. So this is the thing. Now, 2-3 things. We have one gene fund, which is the money they, I mean, government is raising um, for farmers or further agricultural development. One is the gene bank. So, I mean, just to, it's like a bank where all the genomes or all these plant genetic resources, we are keeping it for the better conservation or better protection. I mean, basically for the conservation, for the later they can utilize it. So all this idea actually came from the ITPGR FRA, from the UN one. Somehow not so successful, but we are a signatory country, so this is a binding nature one treaty. So this is the thing. Okay, so I'm now resting myself. I have already exceeded the time.
Thank you so much, madam. Uh, Thank you for sharing your considered opinion. Now I request our chair, Professor G. V. Reddy sir, to please continue the proceedings.
I think that made a very interesting 1 hour of highly scholarly discourse from Dr. Gargi Chakrabarti. And as far as the clarification regarding the GIs and plant varieties protection, she has explained very well. So GIs can be kept in the private domain forever, but the plant varieties will come to an end. The protection will come to an end after 15 or 18 years of registration, depending on the nature, whether they are extant varieties or not. But GIs, if renewed, can be continued forever, like whether it is, we have seen champagne and many other things which are still going strong after 100 years. Anyway, that is one aspect, and Madam has explained very well about Nujividi seeds case, which is still pending. There are certain other interesting cases, of course, not from India, but other parts of the world, like Canada. We have, the Canadian Monsanto versus Miser's case, but that borders mostly the patent protection. So if
Enter into that those cases, yes, sir.
yeah, that was not the issue, but the liability part, especially if they are blown from one protected area to our neighbor's agricultural land, and if there growth there, and very unfortunately the fellow was found liable, though no damages were paid, directed to be paid by him. Then of course we also have certain good developments in the state of Telangana. We have Telangana Sona, in fact, which is supposed to be a very good variety of rice, which can be consumed even by diabetic patients. And yes, and that is another important thing. And maybe one more aspect, I think, which probably deserves the attention of all the policymakers, not only policymakers, but also farmers and their organizations, is the gene fund. How the gene fund could be maintained properly under Section 45 of the Act. But I'm absolutely sure that what Dr. Gargi has explained is, in fact, very clear, crystal clear to everyone, not only from the legal background, but also from the other disciplines. So I once again thank Dr. Gargi personally on my behalf, and I hope that she would be participating in our forum in many more future programs. Now I request Mr. Srinivas Rao to propose a formal vote of thanks. Over to you, Srinivas.
Thank you, sir. Thank you, ma'am. A very good evening, ma'am, and good evening, IPR-Chair Professor, and the organizing team and all the participants. I would like to take this opportunity to thank everyone who has attended this session. Madam, there are many institutions which are working on plants, organics, farming, agriculture, and many more. Also, you have rightly indicated that India is the land of celebrations of plants and agriculture by way of its cultural inheritance like Sankranti, Bihu, Pongal, and many more. But the lacuna is still that we are far behind than other countries in terms of registering and reserving our IP rights in this particular segment. So this presentation of yours today on this platform is more impactful because Hyderabad is a hub of most of agriculture and seed companies. Now the participants who have viewed this presentation is more likely to be more knowledge empowered and knowledge ambassadors, and can be more work on more disseminating their knowledge by identifying the gaps, and can also help us in building the bridges in this trailing IP protection. I'm sure that now few of the viewers will also start working on more colorful agriculture food base by their inventions, and no wonder if someone may invent pink or purple capsicum, there is more work and concentration which is required in plant protection, ma'am. As you have rightly indicated that West Bengal is having more than 100 varieties. Earlier, Tamil Nadu and Andhra Pradesh used to export rice to other states. Today, the situation is completely reverse. Most of rice, especially Sona Masuri or parboiled, is imported from West Bengal, and some rice is even exported to Saudi and South African countries. By your lecture, we have successfully completed 7th episode of our weekly lecture series, Know Your IP, which is one of the DPIIT IPR-Chair OU IP properties. I would also like to take this opportunity to thank my team and every viewers and participants for being continuously supporting us. So before leaving this meet, I would also like to request all the participants to please ensure to subscribe to our channel if you have not done yet. This will help you in getting more updates and viewing our recorded videos. One more thing, now you can also share your open feedback on our YouTube channel with respect to videos being uploaded. So here, on behalf of DPIIT Chair and my team, I thank everyone. We will meet next with yet another interesting topic. Keep supporting us, encouraging us. Until next episode, on behalf of DPIIT Chair OU, thank you. See you again. Thank you, ma'am.
Irfan, Srinivas, Reddy sir, and all the participants for patient hearing and questions. Thank you so much.
Thank you.
Thank you. Thank you so much.